The broadcast is now starting. All attendees are in listen-only mode.
Hi, everybody. This is Charles C. Ballmeyer, Vice President of NetLaw, and welcome to our workshop. I thank you very much for giving me your time on this Saturday. I know you have better things to be doing today, so thank you so much. I hope you get a lot of benefit from your time with me today. I want to talk about some very important issues and go through in detail how you actually use your NetLaw account to create documents for yourself. But real quick, let me tell you a little bit about our company. NetLaw is a technology company that was actually created by the law firm of Hargrove Madden, which is an estate planning law firm based in Louisville, Kentucky. Our technology was recognized by the American Bar Association in 2012, and we were awarded their James Keane Award for Excellence in E-Lawyering. What we decided to do with that at that time was really move this into a different platform so that we could better serve our clients and make the whole process easier for them, and thus NetLaw was born. Here are the documents and services that are included in the plan. You get a last will and testament, probate avoidance revocable living trust, financial power of attorney, medical power of attorney, living will, also known as an advance directive, HIPAA authorization, a life vault, which is a wonderful tool for you as a client. So once you create these documents, you can store all of these documents in your vault. It is a secure encrypted environment, cloud-based environment, so that you can access these documents at any time. But you can also store anything else in the vault, and I would really encourage you to do so. You know, if something were to happen to you, this is a great place and a great resource for your family so that they have one place they can go to find everything. So I'd really encourage you to put copies of your life insurance policies in your vault, your bank statements, your investment account statements, retirement account statements, all of your asset information I would put there. But you can put anything else, you know, copies of passports, birth certificates, even photos, all of that can be saved in your vault. And I also encourage you to really work closely with the advisor that referred this plan to you. They're a wonderful resource for you, and they are more than willing and happy to help you get these documents scanned into your vault. If you're like me, you don't have a scanner at home. My printer doesn't even work, so that can be a bit of a problem. And just to have all of that stored in one place that you can access anywhere, anytime with internet access is a great, great tool for you. So I encourage you to do that. Also included in the plan is access to our national network of estate planning attorneys. These lawyers are vetted for their experience and expertise in estate planning. So if you have an issue or a particular situation where you need the extra help of a lawyer, these attorneys are available and very capable of helping you. So maybe you have a child with special needs and you need a special needs trust, or perhaps you're a business owner and you need to talk to someone about business succession planning. These lawyers will be a great resource to you. Keep in mind, however, that their time and their services are not included in your plan. That will be at an extra cost, and that will be based on their fees and their hourly rates. What is included in the plan, however, is your spouse. If you are married, your spouse can create the same set of documents at no additional charge. So that's 2 sets of documents for the cost of one plan. So that's a wonderful benefit to you and your family. I want to talk about some of the estate planning issues that come to mind when you start thinking about planning. You know, what's really important to you, and what are some of the maybe the hurdles or hesitations you might have when even going down this road or even completing the process of getting your documents in place. And it really boils down to kind of 3 key issues for most people. Number one, we all want to maintain control. I don't think any of us are ready to give up control of our money or our financial decisions or our medical decisions. We want to maintain control over that, especially, you know, your healthcare decisions while you're living. I mean, that's a huge, huge thing for everyone. But, you know, with maintaining that control comes financial security. I've been in this business for at least 20 years, and I have yet to meet an individual who was ready to turn over control of all of their money to someone else. we don't want to do that because we need to maintain that financial security. We want to invest our money the way we want to invest it. We want to be able to spend it the way we want to spend it. And we want to be able to leave that to our loved ones the way we choose to do so. So those are two key issues that are really tied closely together. The next issue that is really important to a lot of people is just preserving your assets and managing those assets, not only for future generations, that's very, very important, but also for yourself during your lifetime. And with proper planning, you can do that. I often talk to clients about protecting your wealth during your lifetime and after your death, and protecting your health, protecting your health care and your health care decisions. And with proper planning, you can do that. So wills and trusts are not just about death and dying. It's not just about after you are gone, but it's about protecting yourself during your lifetime if you have a health event. And I'm going to show you how that works and how you accomplish that with this plan. I want to talk a bit about probate. That's an issue that's a pretty big deal for some people, and in some states, it can be very, very costly. It can be time-consuming, and it can be pretty burdensome for the family. Every state has what's known as a creditor's claim period, and on average, that's 6 months. Now, it can be different from state to state, but most of the states across the country, that creditor's claim period is 6 months. And what that means is that is the minimum amount of time that the estate has to be kept open. It's also a period of time where your assets cannot be accessed by your family. The court basically freezes those assets and has to preserve them to give creditors a chance to come forward and file a claim against your estate. So it really puts a burden on the family. It keeps them from having access to those assets and those funds to buy groceries, to pay the light bill, just to basically continue the lifestyle of the family. A great way to avoid that whole process is with proper planning, with trust planning, a revocable living trust that we'll talk about in just a moment. Now, regardless of whether or not you die with a will, which is known as testate, or if you die without a will, which is known as intestate, any of your individually owned assets are going to be subject to this probate process. Now, an individually owned asset is something that has a title with just your name on it. So a piece of property with just your name, a bank account with just your name, a car that just has your name on the title is a probate asset. And those are the types of assets that are going to be subject to court jurisdiction. Those are the type of assets that are going to be frozen by the court for that creditor's claim period. Now, there are other types of assets that are not subject to probate, and those are non-probate assets. And that would include anything that passes by beneficiary designations, such as life insurance or retirement accounts. Those are going to pass by the designation, that beneficiary designation that is attached to that asset. Likewise, assets that are owned jointly with rights of survivorship are going to pass automatically to the survivor. So regardless of what your will might say, those assets are going to pass according to the terms of the beneficiary designation or automatically to the survivor of anything that's owned jointly with rights of survivorship. Other assets that escape that probate process are assets that are owned by a trust. And we're definitely going to talk about that and how that's not only beneficial from avoiding probate, but how it's also beneficial for you during your lifetime and your family after your death. One thing to note is that if you effectively avoid probate, that doesn't necessarily mean that you avoid paying taxes. Your taxable estate and your probate estate are not necessarily the same thing. Again, your probate estate only includes assets that are owned by you in your individual name. Your taxable estate includes everything, including those assets that pass by beneficiary designation, such as life insurance and retirement accounts, including assets that pass jointly with rights of survivorship, and including assets that are owned by a revocable living trust. So it includes everything. Just want to make sure that that's clear, because sometimes people, I think, have a false sense of security that if they have a revocable trust and have it funded with their assets, that means that they're going to avoid paying taxes at their death, and that's just not the case necessarily. So why execute a will? And what does that really do for you when you have a will? You know, that is, again, whether, to go back to that whole probate process, whether you have a will or you don't have a will, that whole probate process is really, it's something that kind of pulls together all the loose ends of your life. And if you have a will, then you name the person known as an executor or a personal representative that's going to be responsible for handling all of that. If you don't have a will, the court is going to appoint an administrator to do that for you. And it's a pretty important role, so I think that's something that you want to be in charge of, naming someone to have that ability. Your executor is going to be someone who's going to basically take an inventory of all of your assets, have them valued. They're going to distribute them either according to your will or according to state law based on whether or not you have a will. And that's also the person that's going to be responsible for paying final debts and expenses. That's the individual that's going to be responsible for filing your final income tax return. You know, believe it or not, the IRS is not going to give you that year off just because you passed away. You know, they're going to want that final income tax return. So that's one of the responsibilities that your executor or your personal representative will handle. Now, another important reason why you should create a will is so that if you have minor children, you name a guardian to take care of that child. A guardian is someone that basically steps into your shoes as a parent to have the physical care, custody, and control of that child. So what happens if you don't do that? Now, I have a minor child. My daughter is 10. And, you know, my husband and I decided a long time ago who we wanted to raise our daughter. But if we had not named that person in our wills, because that is the legal document that courts recognize, a judge would make that decision. Now, even though we may want my sister to raise our daughter, if we didn't have that in the will, what's to say that my husband's sister wouldn't think that we wanted her to raise our daughter? And you could potentially have family members fighting over the custody of a child, and a judge really doesn't know what you really would have wanted to happen. You know, that judge doesn't know you, doesn't know your family, doesn't know your wishes, doesn't know your child. You know, in some of the worst cases, I've seen children placed in foster care temporarily until the guardianship can be worked out. And that's just a very traumatic event to put on a family and your children. So it's one of the reasons why you really need to take this step. If you yourself do not have minor children, maybe you have minor grandchildren, make sure you talk to your kids about that and make sure that they've got that not only decided, but set out in a last will and testament. Of course, your last will and testament is where you let everyone know, your family, your loved ones, a judge, how you want your assets to be distributed. Without having that within your last will and testament, it's going to be passed according to state law. So what I always tell people is if you don't have a will, your state has one for you, and it's that intestacy law, that intestate succession law. It's going to dictate how your assets pass, and more than likely it's not going to be according to your wishes. So those are some very important reasons why you should create a will. Let's talk a little bit more about revocable trust, and I touched on that when we were talking about probate. And with that trust, and I'm just going to elaborate on that a little bit before we go into the other benefits, but having a revocable living trust and naming that revocable living trust, having that revocable trust be the owner of your individually owned assets prior to your death will keep you from going through that probate process. So rather than having that piece of real estate in your individual name, you would want to have that piece of real estate owned by your revocable living trust. You would want your bank accounts owned by your revocable living trust. Anything in your individual name that you wanted to keep from that probate process, it's a good idea to utilize that trust for that purpose. Because what happens at that time when you pass away, you did not own those assets individually. Your trust did. So it's not subject to that court process, which means it's also not subject to that 6 months creditor's claim period. So your family has immediate access to those funds to continue to pay the bills and buy groceries and keep living just like you would want them to do. So that's one of the major benefits of a revocable trust. Also is the privacy that comes with that. You know, probate is a public process. Again, the court has to publish notice of your death and to give those creditors a chance to come forward. That also means that anybody has an opportunity to take a look at your file, your estate file. They can see what you have, what it's valued at, and who it's being distributed to. That's not the case with a trust. These revocable trusts are not subject to court jurisdiction, so all of that remains private. First and foremost, though, let's talk about the flexibility that this trust gives you. And let's reflect back on those three key issues: control, financial security, management and preservation of assets. With a revocable trust, you are your own trustee during your lifetime, which means you maintain complete control over that trust. You can change it at any time. You can change the beneficiaries at any time. You can put assets into the trust. You can take assets out of the trust at any time. It's at your complete control, which means you maintain complete financial security from those assets. In addition, it gives you the benefit of being able to manage those assets not only for yourself during your lifetime, but for future generations. Again, a lot of times people think about wills and trusts as tools that come into play after you pass away. With this revocable trust and with the financial power of attorney that's included in the package, those are key tools to protect your wealth for yourself during your lifetime. What happens if you have a health event? What happens if you have a stroke or develop dementia? With these documents, you can have your power of attorney can move your assets into your trust if you have not already done so, and then the successor trustee named in your trust can then take over the management of those assets and continue to pay bills and buy groceries for the family and make distributions to and for your benefit, just like you would want to happen, because that's your trust. That's how you've designed it. So this is a key disability planning tool for you during your lifetime. Now, upon your death, again, this is a key tool to preserve and manage those assets for future generations. A lot of times we're protecting inheritance not only for the beneficiary, but sometimes from the beneficiary, from spendthrifts, from future ex-son-in-laws and daughter-in-laws. I mean, I don't know about you, but I can already tell you that I want my daughter's inheritance to benefit her and my future grandchildren. I definitely don't want my daughter's inheritance to potentially go to my future ex-son-in-law and anybody that he marries after her and any children that he may have after her. I don't want that to happen. I want it to stay in my family, benefiting my bloodline, and this is how you do that with proper trust planning. I will point out that during your lifetime, there is no tax advantage, no tax benefit of having this trust. And why is that? The reason for that, again, is because it is at your complete control. Remember, you control it. You can put assets in, which means you can take assets out. You can change the terms of the trust. You can completely terminate the trust. So the trust maintains your Social Security number. So there's no separate tax filings that you have to make every year, which is good. But that also means that it doesn't benefit you from a tax perspective either. In addition, this particular type of trust is not an asset protection trust, which means you cannot set up this trust today and move all of your assets into it and then file for bankruptcy tomorrow and have those assets protected from bankruptcy. The judge is going to say, well, that's all well and good, but go get those assets out of your trust and pay your bills. So again, if you maintain the control, the access, and benefit, those assets are not going to be protected from, bankruptcy, from creditors, and that kind of thing. So I want to make sure that that's understood and that that's perfectly clear. So I want to talk a little bit also about financial decisions and transactions and medical decisions. With your financial power of attorney, I've already talked about how that's a key tool in helping you not only during your lifetime, but if you have a health event. So, again, if you have that stroke or you become mentally incapacitated or whatever the case may be, your power of attorney and your trustee of your revocable living trust work together to make sure that you're taken care of and eliminates the need of a family member of having to go to court and be appointed as a guardian to handle those things for you. So the individual or individuals named in your financial power of attorney have the ability to handle your finances just like you would for yourself. So they can write checks to pay bills, they can vote stock, they can buy and sell real estate, anything like that. With your medical power of attorney and your advance directives, those control health care decisions. So the medical power of attorney, you name someone or a couple of people, it's up to you, to have the ability to make medical decisions for you if you cannot do so for yourself. So if you cannot speak or communicate for yourself, the individual or individuals named in that medical power of attorney can consent to treatment on your behalf, or move you to a more specialized facility, or consent to a particular procedure. That's the kind of decisions that are controlled by that document. With your living will, also known as an advance directive, that's the document that controls your end-of-life decisions. So artificial nutrition, hydration, and respiration, that's what that controls. If you feel very passionately that you be allowed to die naturally without those artificial interventions, you need to let your family know. On the flip side of that, if you want to be kept alive, no matter what, that's okay. That's your decision, but you need to let your family know. And if you really want to ensure that those wishes are followed and that the physicians and healthcare providers are legally required to honor those wishes, guess what? You have to put that in a legal document. Without that, again, a judge is going to appoint somebody to handle that for you. Now, I don't know about you, but it may take me, maybe a second or two to figure out who I would want to make those decisions, but I automatically know who I would not want to make those decisions, right? I think we all know that. And again, a judge doesn't know what you would want and what you wouldn't want. So avoid that situation, avoid, kind of the risk that you might be taking by making sure you have that in place. So, what is your legacy? What do you think you'll be remembered for by your family? Do you want to make sure that you're not only protecting yourself during your lifetime, but that you're protecting your family after you're gone? And, first of all, I commend everybody on this call for taking that step. You've taken that first step. And I hope that you take the next steps to really get through the process and get everything completed. And, with that, I want to hop off of the slides here and move over into a NetLaw account. I want to show you guys exactly how to use your account and how easy it is to not only get started, but to create documents. And I hope that this empowers you to go through this process and get everything completed if you haven't done so already. Now, when you first get into your account, the very first time you log into your account, we're going to take you right to this screen in the Smart Guide, and we're going to take you through this Getting Started process. Now, it's very important that you complete this Getting Started process before you start creating documents, because what we're doing with the information that you're entering during this Getting Started process is we're going to use that information then to make it easier for you to create those documents. Without doing that first, it's going to be very difficult. You're going to have to go back and enter information into My Info and Key People. Otherwise, you're not going to be able to manually type in information. So let's go through this process real quickly, and I will just use myself here as an example. And so basically that means you guys are going to find out all kinds of stuff about me. Like I can't spell, apparently. Oh my goodness. So guys, my birthday's coming up, so please feel free to send me a birthday card. The next section is going to ask for my address, and one of the reasons we asked for this is because this tells us which jurisdiction your documents need to be created in. Keep in mind that NetLaw is not only state-specific, but it's also state-compliant. So depending on where you live and the information you put into this section here, that's going to dictate the state law that your documents are created in compliance with. Next, it's going to ask about my family. Am I married? Do I have children? And yes, I am married. And yes, we do have a child. Notice here it also asks if we have pets. And I do. I have a couple of kitty cats, but I'm just going to say no. And the reason we're asking for that is because our system will actually create a pet trust. So if you have pets that you want to make sure are taken care of after you pass away, this is a great way to do that. A pet trust is a legally recognized trust where you name a caregiver for that animal. You can even dictate what happens to the assets of that trust upon the death of the animal. And in this part of the world in Kentucky where, you know, the equine industry is really big, pet trusts are very common. But I'm just going to click no and continue on. Next, it's going to ask for my husband's information. I'm going to put that right in there. And notice this is asking how he wants his name to appear within his documents. Enter in his date of birth. And here it's asking if his address is the same as mine. And one thing I want to point out with this, the reason we ask that question is, and in Kentucky it's very common, for a married couple, maybe one spouse is a legal resident of the state of Kentucky, but the other spouse might be a legal resident of Florida for income tax purposes because there's no state income tax in Florida. It's very, very common in Kentucky. Well, with one NetLaw account, you can create documents specific to 2 different jurisdictions, one for each spouse at no additional cost. So that's a really great benefit for our clients. But my husband lives here with me in Kentucky, so I'm just going to click yes, or he's a resident of Kentucky. And then I'll click continue. Next, it's going to ask about our children, and we do have 1 child. So to add your children, you just click add right here and enter in their name, how you want that to appear within your documents. Birthday. And she is a child of our current marriage. If I had been married before and had children from a previous marriage, or from a previous relationship, I would click child of a prior relationship. Or if I had stepchildren, I could also enter them that way as well. So I'm going to click OK. And you can enter, obviously, as many children as you have. I'm going to click next. This is asking about advisor information. For those of you invited by your advisor, this information will be pre-populated for you. I'm just going to click no and move ahead. Next, it's going to ask for key people. Now, these are individuals that are going to play a key role within your estate plan, perhaps as executors, successor executor, guardians, successor guardians, so on and so forth. So let's just name a few here. I'm going to name my sister. And when I start typing sister, it drops down here with the options for sister or sister-in-law, so it's easy just to click and continue. Also with your state, you just start typing your state and it gives you the options to click. Let me name my brother. And I'm going to name one more. I'll name my sister-in-law. And there they are. There's all of my key people. If I decided to go back and revise my documents, I could certainly go in and remove a key person and add more key people if I wanted to. But that's all I want to add for now. I'm going to click next. This is going to lead me through some questions that really should get you to thinking about what's important and how you really want things to happen when there is an event, a health event or a death event or things of that nature. So if I were to become seriously ill, if I were to have a serious health condition, I would want someone to have the ability to make medical decisions on my behalf if I was unable to do so. I would want those individuals to have the access to my medical information and to be able to speak on my behalf so that they could take care of me. Next, it's going to ask about end-of-life decisions and how I would want that to be handled. And I do want to declare what I want to happen in that situation because I do want to ease the burden of making those decisions from my family. I don't want to put that on them. I want to make that decision. And I want to make sure that my physicians are required to honor those decisions. So I'm going to check all of those. Next, it's going to ask about providing for my family while I'm still alive. How do I want my financial affairs handled? And yes, I want to have the ability to have someone that I know, I love, and I trust to make those decisions on my behalf. I want the peace of mind of knowing that that's taken care of. Or maybe I'm just traveling and I need somebody to handle that for me while I'm gone. Whatever the case may be, you can check all of those or any of those. Next, what's going to happen after I pass away? What do I want to happen after I'm gone? Yes, I do want to decide who gets my property. I want to make that decision. I don't want that to be left up to a court. I want to decide who raises my children. I definitely want to reduce the cost and burden of probate on my family. I want to make sure that my heirs, my beneficiaries, get their inheritance as quickly as possible without having to be delayed through that probate process. I want to make sure that my child's inheritance is protected. And I want to make sure that the distribution of my assets are private and not subject to court jurisdiction and public record. All very important decisions. Based on those decisions that I've just entered, this is what the system is recommending for me, which is not surprising because these are the foundation blocks. These are the building blocks of a sound estate plan. So what's going to happen when I click Finish is this is actually going to create a recommendations letter for me based on the responses that I've just given. And then it's going to populate that recommendations letter in my vault. And again, that is the secure encrypted environment where you can save all of this important information. And it's really very easy to do so. I'm going to show you how to do that. Okay, here we go. So here is my recommendations letter that I just mentioned, and this is the vault. And all of these folders here, those are pre-existing folders. So we've already created those for you. So if you want to save your insurance policies in your vault, copy of the deed to your home to your vault, financial information, tax returns, etc., you can do that. So let's say that you've scanned all of your life insurance policies, or better yet, you've taken all that stuff into your advisor and you've let them do it for you. That's even better. The way you put that information into your vault is you just click on that folder, and you'll see it pops up here. Click on Upload File, and then you're going to find where those documents were saved on your computer. And let's just click on Life Insurance Policy here. Click Open, and in a moment you'll see it'll pop right into your Insurance Policies folder, and there it is, which means that now I have the ability anywhere, anytime with internet access to access that information and anything that I put in there. If I wanted to create other folders, maybe I want to put copies of my passport in here. I would just create a folder that says Passport. There's Passport. Click on that, click Upload, find that document, and just upload it right into that folder. You can even drag and drop between folders to help organize after you get everything uploaded into your vault if you want to do so. So this is a very, very easy tool to use, and it's so beneficial. It's so helpful. I actually use my tax returns folder quite a bit. Throughout the year as I'm making charitable contributions and I'm writing checks to the PTA and I'm dropping things off at Goodwill. I just scan those receipts into my tax folder. Then when my W-2s are issued and 1099s, I put all of that in my tax folder and then share that one folder with my CPA. He can pull that information out, create my tax returns, and then load that tax return back into my vault for me. And I never have to go see him, which is a big time saver. And just, I mean, who wants to go hang out with their CPA? It's kind of like going to the dentist. You do it because you have to. But anyway, so once you've gotten, your recommendations letter is populated here in your vault, to begin creating documents now, you're going to go to your Smart Guide up here at the top. Just click on Smart Guide. And that is going to load the screen where all of the legal documents are listed so that you can now begin creating legal documents. Before we do that, I want to show you one other thing. So a lot of times we get questions about, how do I create documents for my spouse? I've created all of my documents, but now how do I create documents for my spouse? To switch back and forth between yourself and your spouse, you're always going to be on this Smart Guide page, and then over here to the right where it says Document For, that's who you're creating a document for. If I want to start creating documents for my husband, I click the drop down and then I just click on his name. To go back and make changes to my documents or to create documents for me, I simply go back to this drop down and click on my name. It's really, really easy. I also want to point out that you do not have to duplicate data entry. So any information that I have entered that is common between the two of us is going to populate in his Smart Guide as well. So you don't have to re-enter the name of your children. You don't have to re-enter, key people if he's going to name the same key people. If he's not going to name the same key people, he can add some different key people when he starts doing his own documents. It's very easy to do. So now let me just walk you through the process of creating a will and a trust. Every document comes with a little video that you can watch that will tell you a little bit more about the document and what it does. But I'm just going to skip right over that and go right into the process of creating a will and revocable living trust. You'll note that to start us off here, it's asking for us to name an executor of the last will and testament. I want to draw your attention over here to the right under Helpful Tips. We've got a lot of QA here that is related directly to what we're asking about. So we're asking for you to name an executor. Over here to the right, we're going to tell you more about an executor, what it is, and things that you need to think about and consider. I also want to point out this Help tab. It's a very robust FAQ section where you can find the answers to a lot of the questions that you have. However, if you can't find your answers there, you can always call us. And if it's also during business hours, we have online chat that you can access from here. So we really try to go as far as we possibly can to give you as much help and assistance as possible. But let's go back here and let's start creating our document. To name an executor, you just simply click the drop down, and everyone that you named in that getting started process, from your spouse to your key people, if you had adult children, they would be listed here as well. My daughter is only 10, so her name's not listed here. So again, just click the drop down and then check the name of the individual that you want to name as your executor. I'm going to name my husband Blake as my initial executor, and then click next, and it will ask who I want to name as an alternate executor. So if Blake has predeceased me, or if he is unwilling or unable to serve in that capacity for whatever reason, I can name someone as an alternate. I can name one person, or I can name multiple people, or I could click none and not name an alternate at all. Let's say that I want to name one person. So I would click that option, choose the drop down, and you note here that Blake's name is no longer listed because I've already named him. So that eliminates the possibility of making a mistake and duplicating his name twice. So I will name my sister. Now I could name multiple people by clicking multiple people and then clicking the drop down and naming my sister and my brother if I wanted to. But I don't, so I'm going to uncheck his name, go back here, click one person, and move to the next field. Next, it's going to ask about guardians for my minor child. I do want to point out that if I had put in here that my daughter was over the age of 18, I would not be seeing this question right now. So it recognizes when I entered in my daughter's information that she was under the age of 18. So it's going to prompt me with this question. Also, again, want to point out that over to the right is more information about guardians and guardianship. So to name a guardian, you just simply click the drop down and choose the person you want to name in that capacity. Click next to name an alternate guardian for my child. Super easy to use. I hope you're seeing how this just leads you through every single step. Again, you could name one person or multiple or none. I'm just going to name one. It works exactly the same as executors. I'm going to name my brother and then click next. Trustees of my living trust. Now, if you'll recall, when we were talking about revocable living trust, I mentioned that you are the trustee of your own revocable trust during your lifetime. So that's what this says here. You will serve as the initial trustee of your living trust. So what you're doing here is you're naming an alternate trustee, a successor trustee. So either upon your death or your incapacity, this is the individual that will step in and play the role of trustee. You can name one person, multiple people, or you can choose not to name one if you do not want to. I'm going to name one successor, and I want that person to be my husband. And then just click next. Possible future trustees. So what this means is, basically there's a lot of different things that can happen, and it is possible that the individual that you've named as your successor trustee may pass away before the trust ends. So what would happen at that point? So what this is asking for here is, would you like to give the ability for any adult children or any adult, say, descendants, which would include grandchildren, do you want them to have the ability to serve as trustee of your living trust? This actually defaults to the age of 35, so they would need to be at least 35 before they could become a trustee of the trust. If you click yes, then you're allowing them that ability. If you click no, then basically you're stipulating that you want a bank or a trust company to serve as successor trustee. So I'm going to click yes. And keep in mind that with this trust, you can change this at any time. Again, it's at your complete control. So today, you know, my daughter's 10, and she's a fantastic little girl, and actually just had the most amazing progress report for school, got all A's, and we're very proud of her. But nobody knows what's going to happen in the future, right? So we want to have the ability to make those changes. Now, specific bequest. This is where you can make specific bequests of items or of money. So what I want to show you here, there's two different types of specific bequests you can make to an individual or a charity, and I want to illustrate how you do that. So click yes. You don't have to leave a specific bequest if you don't want to, but I just want to illustrate how easy it is if you do so, and I'll show you how to do both types of bequests. We'll start with, you click add here to do that, and then let's start with making a charitable bequest, and I want to benefit the Red Cross. Of Kentucky. Now I can leave a dollar amount or I can leave an item. So I could leave them a car, I could leave them a piece of property, I could leave them stock. In this example, I'm just going to do a dollar amount, and let's say I'm going to benefit them with a $10,000 bequest. Next here, I need to indicate whether or not I want that bequest to be made, regardless of whether or not my spouse is living at my death, or only if my spouse has predeceased me. So if I choose regardless of whether or not my spouse is living, then basically, you know, that means if he's living, that bequest is going to be made. And if I've left everything to him, that $10,000 is going to come off the top before he gets his the rest of the assets. If I click only upon my death, then obviously he has the access and benefit of that money until he passes away. So in this particular case, you know, my personal preference, I'm going to say I only want to make that bequest if my husband has predeceased me, and click OK. And there's the bequest right there. And let's add a bequest to an individual. So I am, and again, you click the drop down. If there's someone that you want to make a bequest to and they're not in this drop down, you would simply just go back to key people, add that person in as a key person, and then go back to this section of the legal document and just click their name from the drop down. So here I'm going to click my sister, and let's say I'm going to leave her an item. I want to show you over here where it says describe the item but do not include the word my in the description. So for example, if I want to leave my grandmother's ruby ring to my sister, I'm just going to type in grandmother's ruby ring. And the reason for that is because the word my is already in the document. If I put the word my in here again, it would say, I want to leave my grandmother's ruby ring to my sister. So we don't want to do that. And down here, I don't really think Blake cares about my grandmother's ruby ring. So I'm going to say I want this bequest to be made regardless of whether or not he's living at my death. Click OK, and then click Next to continue. Now your remaining property. So we've made those two specific bequests. So everything else that's remaining, this is asking how do you want those assets to be distributed. And your choices here are all to my spouse if surviving, if not to my children in equal shares, or you could choose all to my children in equal shares, or you could choose to name persons and or charities. Let me click on this choice here, this third choice, just so you can see what that looks like. It's very similar to how you would create specific bequests. So by clicking on that, you can name in charities, you can name individuals and the percentage that they are to receive. So you can get very, very specific. I'm actually going to go back and choose a different option just based on my personal situation. I would choose for myself all to my spouse if living, and then if not, to my children in equal shares. But again, that's a personal decision, and whatever you wish to do is perfectly okay. Next, it's going to ask, how do I want my child's inheritance to be handled? And it even gives you the option here of omitting a child. I know that sounds harsh, but there are instances sometimes when you would need or want to omit a child. Maybe you've got a child with a substance abuse problem, or maybe you've got a child that's just recently been sued, or whatever the case may be. You might want to omit that child. And if that's the case, you would just click yes, and then choose the child from the drop-down if you have more than one child. I don't want to do that, so I'm going to click no. And then it's going to ask if I want my child's inheritance to be held in trust. And I do. She's 10 years old. I don't want the risk of her receiving her entire inheritance in one lump sum when she turns 18. So I'm going to click yes and then continue. And then it will give me the options of how I want those assets distributed out to her. Which is a wonderful benefit. This is a great way to protect that inheritance for her and from her and for my future generations here. So the options that this gives me is holding the assets in trust for her benefit and giving her outright distributions, 1/3 when she turns 25, half of the balance when she turns 30, or the remainder at 35. Or I could hold everything and give her half of the trust when she turns 25 and the balance at 30. Give it all to her at 25 or all at 21. Now I'm going to choose the most restrictive choice just to try to protect those assets as much as possible. Now this doesn't mean that she can't have benefit from these assets. This just means that these are the ages that she has to reach before she gets any large outright distributions. The trustee always has the ability and the duty to provide for her health, education, support, and maintenance in addition to those distributions at those certain ages. Next is the ultimate distribution. This is, just to use myself as an example, what that means, because it can be a little bit confusing. The ultimate distribution is what happens when you pass away if there is, if you don't have any beneficiaries living. So if I were to pass away today and Blake wasn't living, our daughter Brooke wasn't living, I didn't have any grandchildren living, what would I want to happen to my assets? And the choices we give you are you could leave everything to your heirs at law, or you could divide those assets 50-50 between your heirs at law and your husband's heirs at law, your spouse's heirs at law, or you again can get very granular and name specific individuals or charities and the percentages that you want those assets to be passed. Now again, based on my personal situation and my personal preference, I'm going to click 50-50, 50% to my heirs at law, 50% to my husband's heirs at law, just simply because, more than likely these are assets that we've built and accumulated together during our marriage and our lifetime, and I just want to benefit both sides of the family. Now an heir at law, for those of you that don't know that term, again, that would be my siblings, my nieces and nephews, cousins, so on and so forth. And those individuals would only benefit if I did not have a husband living, children living, or grandchildren living at my death. So that's what that clause actually controls. Let me click next. And this is going to give us the indication that we've gone through the process and we have finished answering questions for the will and the trust. So you click Finish, and what's happening now is the system is actually pulling in provision by provision to create these documents for you. NetLaw is not a fill-in-the-blank form system. These documents are actually customized for each client based on the responses that you've entered into the system, again, based on your personal situation and your personal wishes. Once those documents have finished compiling, they're populated here in your vault. So you can see here, we've got your last will and testament, and we've got your signing instructions, what we call execution instructions. I know that's kind of an unusual name when you're talking about creating documents that have to do with your death, but those are just your signing instructions, and they're very specific to your state. So some states may require 2 witnesses and a notary. Some states might require 3 witnesses and a notary for a will. So it's going to be very specific to your state. Now down here are all the documents related to your trust. So here is your trust document. Here are the funding instructions. So if you actually want to take advantage of this trust to avoid probate, this is going to tell you what you need to do to accomplish that. So you're going to have to retitle your assets into the name of the trust, and this funding instructions document will tell you exactly how to do that. Also included here, again, are signing instructions, execution instructions for properly signing that document. Keep in mind, all of these documents need to be downloaded, printed, signed, witnessed, notarized before they're legally binding and effective. So what I'm going to do now is open the will, and I'm going to open the trust and show you what those documents look like. So first, let me open the will. I'm going to click Enable Edit to make it easier to see. And here is my will, created according to the laws of the state of Kentucky and according to the directions that I inputted within the system while I was answering my questions. There is my specific bequest to my grandmother's ring. Again, note the word my. If I had put my grandmother's ring in the system when I was making that bequest, it would have said my. So again, don't do that. Tangible personal property, anything that I have not bequeathed, passes by that provision to my husband if he's living, if not, then to my children. And then everything else that I own, my will is going to say pour that over, distribute that over into my revocable living trust. So if you've heard the term pour over will, P-O-U-R, that's what this is. So let's say that I've set up my will and trust today, and I've funded it with all of my individually owned assets. I've moved all of my individually owned assets into my trust. And then I put these documents in a drawer and I forget about them, and then life goes on and I buy a new car and I open a new account. Maybe I buy and sell real estate, and I forget to put those assets in my revocable trust. So what happens? Well, the will is going to get them to their trust anyway upon my death. So whether I do it during my lifetime or whether the will distributes those over into the trust upon my death, everything's going to wind up in my trust upon my death so that it's distributed according to those terms. So that's what a pour over will does. Here are my executor provisions, executor powers according to the laws of the state of Kentucky, my guardianship provisions. So you can see this is a very robust document. This is a very detailed legal document, and this is exactly the same will that you would get if you came to our law firm in Kentucky and paid us thousands of dollars for these same documents. You can have that for hundreds of dollars instead with NetLaw. So now let me open up the Revocable Living Trust and show you what that looks like. And here it is. Here's my revocable trust that I've just created. It identifies me. It names the trust, identifies my husband and my child. I want to point out that also in this document, just as in the will, it says that, my child, the term my children herein refers to my daughter Brooke, and any child or children hereafter born to or legally adopted by me. So if Blake and I have more children, or if we adopt children down the road, they're going to automatically be included in this trust, whether I go in and update it or not. I certainly can do that at any time at no additional cost with NetLaw, but let's say I forget to do that. It's not going to put that child in jeopardy of not being able to benefit from my estate. So that's pretty important. Let's move ahead here, and I'll show you a few other provisions. Here's that specific bequest to the Red Cross that I made when we were going through that process. And upon my death, you can see here that this will be benefit my husband if he survives me. Then if not, this is what the trust says. It says that upon my death, I want my assets to be divided into equal shares. Now, I only have one child, but let's say that I have two children. I've got Brooke and I've got little Johnny. So what happens here is it would divide those assets into two equal shares. But let's say that little Johnny passes away before me, but he has children of his own that are still living. So this says hold one share for each of my children that are living, and one share for any child that has predeceased me but has children of their own. So little Johnny's children are going to be taken care of. They're going to get benefit to his share of the estate. Now, if little Johnny passed away and he didn't have children, then everything would just be held in trust for my surviving child. Article 7 here shows the provisions of how that trust will be benefit to my beneficiaries. So again, the trustee of this trust, as long as those assets are held in trust for my child or my children, the trustee is going to use those assets to provide for the health, education, support, and maintenance of my children. And they only get access to those large outright distributions at ages 25, 30, and 35. So that's a really great benefit. So I just wanted to show you what these look like, show you really the scope and breadth of these documents so you really have an appreciation of what you're getting with NetLaw. And with that, guys, I thank you so much for your time. There's just one other thing that I want to mention and one other thing I want to show you, and then I'm going to let you go and enjoy your day. You know, as we're moving into the holiday season, you know, this coming week is Thanksgiving. We've got Christmas right around the corner. We're all going to be spending a lot of time with people that we love, with, you know, friends and family and loved ones. And this is an important conversation to have with them. And again, I commend you for taking the step to get this in place for yourself. But what about those that you love? Do you have brothers and sisters that have young children? Do they have this taken care of? Do you maybe have grandchildren? Have your children taken these steps to get these documents in place? You know, really have this conversation over the holidays with those that you love. Maybe share with them that you've completed this process for yourself. And, you know, if any of those individuals need help with this, if they need these documents, you can just click on Refer a Friend right here. And then from here, all you have to do is enter in their first name, last name, phone number, and email. And we'll send them an email with a link to get started, just like you received when your advisor referred this plan to you. And we'll lead them right through the process to create their documents just like you did. So I really encourage you to do that. You know, there's going to be a lot of traveling over the holidays. We want to make sure that those that we love are protected and they're protecting their families. So thank you guys so much. I hope this was helpful. I hope you got a lot out of it. And, you know, have a wonderful Thanksgiving, a wonderful holiday season, and please let us know if we can ever help you with anything. Thanks so much. Bye-bye.